mergers and acquisitions on H1B and L1 visa holders. An issue of heightened concern in recent years with the frequency of corporate restructuring, mergers and acquisitions, spinoffs, or other actions is whether a new or amended visa petition must be filed for H and L workers. The rules differ with respect to H1B visas and L1 visa holders. The H1B visa holders, a change in corporate structure does not necessarily require an amended petition. A new employer is not required to file an amended petition and the new labor conditions application, the LCA, with respect to transferred employees, even where the new employer has a new federal employer identification number, the EIN. If the new employer assumes all the obligations and liabilities of the LCA in immigration-related matters. The employer must keep a list of all H1B visas workers transferred to the new company and maintain the public access files. The public access files should contain the following: a copy of the LCA for each transferred employee with the certification and date, a description of the wage determination system used, a copy of the EIN, and a sworn statement by an authorized representative of the new employer expressly acknowledging the assumption of all LCA immigration obligations and liabilities. If any transferred employee is moved to a new location that was not covered under the LCA filed for that employee, the new employer will need to file a new LCA and amended petition. Let's take a quick look at a case. Company A, a software development company, was recently purchased by the Grabo Corporation. Company A has 11 H1B employees working at its headquarters in Houston, Texas. Grabo Company is not planning on moving any of the new employees to other locations. It does not want to bother with the time and cost of filing new petitions for these employees and opts just to add its statement to the public access file. The Vice President for Human Resources writes a letter acknowledging that it has purchased Company A and that Grabo Corporation will assume all the responsibilities and obligations for the H1B employees. L1 visa holders. Any change in ownership triggers the need to file an amended petition for our L1 employees. This is due to the qualifying organization requirement for L1 visa holders. The new entity must show that they continue to meet one of the USCIS definitions as an L1 qualifying organization. The filing requirements. There are two options available regarding L1 and H1B transferred employees. The first is to seek USCIS confirmation that amended petitions are required, a letter outlining the details of the transaction or organization or reorganization with conclusions on whether amended petitions are required is submitted to USCIS headquarters. USCIS will respond with its instructions on any filings required. The second is to use the class representative approach, where a single representative form I-129, of course with the fee, is filed with all the affected employees' names listed on an addendum, to be followed by actual applications at a later date if required. The representative petition would give all the facts regarding the new structure and the continued qualifying relationship for L1 purposes. If the company has a blanket L approval, it can be amended to cover the new list of qualifying companies. Then any employee transferred to the qualifying companies are covered. The benefit of both options is that USCIS is clearly put on notice of the changes and the employer is allowed to proceed with business. The regulations indicate that a filing after the reorganization has been completed is allowed. Additionally, the employer can request that all amended petitions be filed at a single service center. Contact VisaPro if you have any questions on how corporate restructuring, mergers, and acquisitions will impact you. Our experienced attorneys will be happy to assist you.